Hello, I'm Geek here. Unfortunately, this is the video at which we actually realized that there was a problem with the audio system in the freeway track. We got everything working the night before, but then someone, I don't know, kicked the cable out or something. If you want to see the very tail end of this talk, it starts about the 36 minutes.
him to open them. What they would have done in that instance is they would have seized those phones and they would have said, you know, you have to open them one way or the other. And, you know, in that instance, because there was a biometric versus PIN code issue, they used that to their advantage. But, yeah, I mean, I think they would have got it either way.
I just took it out.
So there's no way for you to just, I mean, they can in contempt of court and you just sit there and rot away until you say yes, and you're like, do that, or,
That's what's happened. That's what the trend has been. If they really want you, they're going to make you do it.
I don't want evidence. You cannot reject blood sample tests. That's illegal. So there really is no recourse that you see at this point.
Right. Go ahead.
What would you think about password managers in particular? Like I know LastPass is a good example where you could create a 20-character random password that's stored in a encrypted database with
Right.
your own master password. If they're looking for a particular type of information, you can legitimately say, I don't know that password, and it's stored in a password manager.
Right.
Is that some mitigation protection, or is it basically, sorry, you're still going to have to do it?
You know, actually, it's not. There's a case that I didn't put in my slides this time, but it wasn't that exact thing. But this lady said, you know, she was a lady from Florida who got arrested. Her laptop was encrypted, and they asked her to provide the password, and she tried, and she said she forgot. She just forgot, and she was for real that she forgot, but. You know, she was still in court for a long time, and they eventually hired a company to crack it, and the government did. They hired a company to crack it and got into it. So the answer to your question is no, it's really not any better defense, because they're going to look at it the same way as they did this lady, where she just forgot.
Previous question. When people do not know their password because they're using password managers, will that spark law enforcement to subpoena the companies that has those password managers to cooperate with them in their investigation?
Yes, it absolutely will. And you know, when the encryption issue first heated up, the federal government issued an order to all the encryption companies in the United States and said, we have to have the key. And all of them complied except for this one company. And in my research for this talk, I found who they were, and I can't remember right now. I'm sorry. But this one company said, we're not doing it. We're just not selling encryption anymore. We're done. Go ahead.
So if they come to me and they say, give me your password, and I say, well, I don't know what it is, like it's LastPass. I have to open up LastPass. Once I do that, does everything that I have stored in LastPass become admissible to them? Because that's a lot more information than what they ask for.
Yeah, it is. And, you know, there's a lot of admissibility rules, especially in court. And you know, the answer to that is no. Everything's not. That's why in the search warrant, they have to be specific about what they're looking for.
So if they're asking you to do it, make sure that you get something in writing that's very specific. I know you need to do that.
Right. Yeah, and they're not allowed to nose around anywhere else.
Okay.
I mean, that in physical law enforcement, that's called the plain sight rule.
Right.
You know, if I go into your house and I see the bag of pot, I could do that. But if I don't go into your house with a warrant to search around, I can't. Go ahead. What? I think it started with B for some reason, but that may be right because love a bit. Maybe what I'm remembering. It could be.
That email company,
Yeah.
yeah, you lost it.
Yeah, that was probably it.
They closed it down so they couldn't get it.
Right. That's what they did. Go ahead.
So a comment on the ability of password managers to be able to cooperate with law enforcement. I know LastPass is a zero knowledge. They don't actually have the information they need in order to give law enforcement access. Other password managers store it locally. But in the case of a password manager, aren't you being compelled to provide law enforcement with the password if opening the password manager reveals the password to them?
You are. Yeah, that's right.
So using a password manager means that you wouldn't be able to be compelled to unlock whatever account because the only way to do it would be to give law enforcement the password.
You said password too many.
Yeah. Somehow that went in a circle, but the short answer to your question is and they're not going to let you trick your way out of it by using that.
My point is that in the case where they appealed to the district court, they were able to say, we don't want the passwords, we just want them to open the safe.
Right.
Where in the case of giving them access to a password, if you don't know the password to it, you have to access the password manager and give them the password and the password manager, then you are giving them the password, not just access to it at the same time. Right?
Yeah, right, I got you. And you know, the other thing is that the thing you have to remember about federal court is there are 11 districts. Okay, it's like I said, magistrate judge, district court, and then there are 11 circuits. And law can be different. The right to report, that's state law. Law can be different in the 11 federal districts. Until the U.S. Supreme Court decides on something, it's not the law everywhere. So, you know, that case that I read was from New York. And, you know, so that would mean here, where we're in a different district, that this federal court may deem it a little different. And until there's a unifying case that the United States Supreme Court, and that's primarily, if you wonder what cases the U.S. Supreme Court accepts, they really accept cases that where there are conflict between the districts so that they can unify the law across the whole country. That's really kind of how that works. Go ahead.
So if you had two-factor authentication and you destroyed the things you had to have,
Yeah.
are you now bound for destroying evidence?
Well, yeah, they charge you with spoliation of evidence is what that's called. And I'll talk about that here in a minute. Now, the last three parts of the CFAA are knowingly accessing a protected computer with the intent to defraud, thereby obtaining anything of value, knowingly causing transmission of a program, information or code or command that causes damage or intentionally accesses a computer without authorization. You know, we all do that. Knowingly with intent to defraud, trafficking a password or similar information through which a computer may be accessed without authorization. Here's a few cases about the CFAA. United States versus Kramer. This is a guy who, what's important about this case is this is a guy who was a pedophile that talked this young lady into meeting to have sex, but they charged him under the CFAA because they said he did it with his cell phone, and the court ruled that the cell phone was a computer. So any of these rules apply to your phone too. We all know about the Bradley Manning case. That was part of the WikiLeaks, the big leak case. He went to jail. This is an interesting new case. This is just from this year. Craigslist versus 3Taps. 3Taps was a company that did a scraping of Craigslist real estate listings for they developed its own cool new interface to do Craigslist real estate listings. And Craigslist said, no, you can't do that. Sent them a cease and desist order and IP blocked them. Well, they kept doing it anyway. So this is what the judge said. He said, the average person does not use anonymous proxies or to bypass an IP block in order to enforce banning communications via personally directed cease and desist order. So the judge said, 3Taps, you really can't do that. You can't hack around their IP block and keep doing it. So they charged them under the CFAA. This first case here is just one that just shows how incredibly stupid people are sometimes. The school district in Marin County, Pennsylvania decided it would be really cool to give all their students laptops, but they didn't want anybody who wasn't a student to use them, so they thought it would be the way to prevent that would be to set the webcam to take a picture every once in a while so they could see who was doing it. So at the end of the day, they ended up with 66,000 web shots and screenshots of pictures of girls in their bedrooms. Yeah, that didn't go well for them. And then here's a couple of other things that are just of note. You know, they charged a guy who stole a bunch of data from his clients and used it to start his own business. And then there was another guy who deleted a bunch of stuff when he left to cover up his bad behavior. Those are all no-nos. Statute of limitations, real quick. You know, you may say, Matt, I did something, but boy, that was a long time ago when I was young and stupid and didn't know any better. Well, how long do I have to sweat before they can come and get me? The answer is typically 2 years. In the absence of a specific statute, the default's 5 years. There are a couple of exceptions. Acts of terrorism are 8 years, or the worst one, of course, if you hurt somebody or there was an imminent risk of hurting somebody, then it's forever. If the police are coming after you, can you record the police? Anybody know the answer to that? Yes, you can, but here are the caveats. Here are the caveats. In 38 states, it's plain, law is very clear. In 12 states, and there's the list, you have to request. Now, keep in mind that there's a distinct difference in the law between a video recording and an audio recording. In 12 states, you have to have both parties' permission to do an audio recording. But in all but 2 states have an exemption, and the exemption is expectation of privacy. If you're in a public place like here or on the street, you have no expectation of privacy for anything you do or say, so you could be recorded. Except for these 2 states, Massachusetts and Illinois, they are the only states that have not upheld that expectation of privacy. So unless you're in Massachusetts or Illinois, you can record away. Now, rule number 2 about this is do not secretly record the police. Openly recording the police is different than secretly recording the police, and there have been some cases about that. And rule number 3, just kind of use your head and don't respond to the cops. They will lie to you, they will intimidate you, and they will try to bully you into stopping doing it. Just be nice. Don't respond, because if they do, they'll arrest you. Now, what do you do if you run into this guy? The first thing you do is shut up. Do not be like Ron White, who said, "I knew I had the right to remain silent, but I did not have the ability." Don't do that. Rule 1.5. Don't do anything. Don't smash your 2-factor authentication key. That's bad. Number 2, call a lawyer. Number 3, this seems self-explanatory, but I see it happen all the time. Do exactly what the lawyer says. Now, what's the first thing? I've been in this situation many times. What's the first thing the lawyer's going to tell you? Shut up. That's the first thing he's going to say every time. Seen it happen. Any other questions? Sorry if I ran it kind of soapboxy, but that's just me.
So, in the beginning, you were talking about the errors and omissions insurance. Are you aware, does your corporation or company you work for have any obligation, if they're the ones who are purchasing that, of course, you doing your job, to always have that available to you? Or can they be like, we think you may have messed up, we're going to leave you high and dry?
That's going to depend on your employment contract. The question was, is your company obligated to carry errors and omissions insurance on you? And, they should. It would be kind of crappy if they didn't, in my opinion. But, if your employment contract says, we don't have to. Now here's the other thing. If you are working on an engagement and you break something or you cause something to happen, you were on an engagement that was contracted. You weren't the one that was contracted. Your company was contracted. You were acting as an agent of your company. I can tell you from my law firm's perspective, we wouldn't sue you. We would sue your company because you are an agent on behalf of your company. That's an important distinction. Now, if your company said, this is the twist to that, if your company said that you are working outside the scope of your employment, then you're on the hook, not them.
Are you aware of cases where that happened?
Yeah, and it's never been in the information security industry. Like the case that first comes to my mind is there was a traveling salesman who was driving down the interstate, and he was talking on his cell phone, and he ran over this lady and killed her. Okay, now he said that he was doing that when I was on a sales call. He was under the scope of his employment. We couldn't sue him; had to sue his employer. His employer, however, looked at his sales route and said, you weren't on the way to a call, you were on the way somewhere else, so you're without the scope of your employment, you're on your own. You're fired. So, not in the information security industry, but same concept. Anybody else before we're done? Yes?
For the VPN giving probable cause for FBI thing that's coming through, has any large enterprise come to the defense of their own product
I would hope that will happen, and hopefully before this gets too far along, there'll be as part of why I put this slide in here, because I want people to be talking about that. That needs to get out there. The EFF needs to get involved. The big encryption companies, like you said, Cisco and stuff, needs to get involved. I mean, there needs to be some racket about this. I was shocked when I read that because I hadn't heard about it, and it was months ago. So, anything else? Thanks for coming. Go see Bill.